We're here. We're here. We are here, guys. Happy Wednesday to you. Hope you're having a wonderful Wednesday afternoon. We're getting used to our power week. You know, what does that mean? That means that we are stepping away from the ASAP Rocky trial. Things are starting to calm down. And there's so many crazy trials happening right now. We have Karen Reed. We have Donald Adelson, who's like showing up to court shaking, just shaking. Right. We have all of that going on. But I'm not taking my foot off the gas because Diddy's case is coming. Cinco de Diddy is coming. It's almost here. Cinco de Diddy is 8 weeks away. And so what we're going to be doing is checking out these legal documents as they come in because there's significant news there. We might be jumping into some Epstein stuff because it's kind of, I don't know, it might be related. It might be related. I don't know. How are y'all doing today? Let's come to the chatterhood. See how chat is doing. Miss D was first. Good to see you, Miss D. She was first today. We saw Chi-Town in here. Good to see you, Chi-Town. Hope you're having a great day in Chicago. Audrey popped in, says, hey, AV in chat. Hey, sis. Hope you're doing well. Good to see you in the chatterhood today. Daniel Cunningham. Cases and Cams with Daniel Cunningham is in the chat. Good afternoon, my friend. D, we know D's gonna be in here. He's always here. Deonra, the conservative Walton, is in the building. Says good afternoon. D, I hope you're ready to jump into these interesting documents, guys. I mean, some of these Diddy documents, you just start to see how they unravel things. And hold up. We have a poll up. Did Buzbee's issue with Jay-Z open this can of worms, guys? That's what we're going to be looking at right now. So on your way in, hit the like button for me. Vote in the poll. This is an interactive stream always. I love these power hours because we can really dive into legal news and legal issues very quickly. We look at the receipts over here. Always the receipts. We always have them. We look at those things and we go from there. So good to see you, Deonra. Grace says Cinco de Baby Oil. It's not Cinco de Diddy, AV. It's Cinco de Baby Oil. I mean, I was watching, because I've been doing some research on this case heavily. We're launching a docu-series for y'all on Fridays moving forward. There's so many things we're working on. But coming up to Diddy's trial, it's very different from what we've traditionally done. Traditionally, we are able to look at what's happening in a courtroom and go from there. Something like this, where a trial is not televised, well, we got the internet, court of public opinion. So we got to get creative on how we cover this one. The good news is that we are able to glean a few things from Jay-Z's case and why. The reason why it's related to Diddy, as Diddy and Jay-Z allegedly did this thing to Jane Doe. And who was the attorney that filed that claim? Tony Buzbee, right? And we just heard that Jay-Z could move forward with a defamation case against Tony Buzbee. Diddy is also saying, Mr. Tony Buzbee, you know what we have to do, chat? You know what we have to do? We have to look at the receipts. Tony Buzbee, we need to show you Exhibit A. In the state of New York, you filed a Pro Hac Vice thing, right? You filed it. You had it in the state of New York. But was it valid in the Southern District of New York, which is federal? We could talk about diversity jurisdiction. I can teach you guys about all of that. This man filed 22 lawsuits and wasn't even authorized to practice law in that jurisdiction. What are we doing? You hear the crickets? I hit that by accident. What are we doing? So this is actually a problem because if 22 lawsuits are open right now, Buzbee didn't even have the legal authority to file them. He's a Texas attorney. When you are barred in one state, it doesn't mean that you're barred in all of them. Last year, when I was ready to take the bar exam, one thing that was important was taking the, uniform bar exam, where you can get barred in many states by taking that bar exam. Some states require you to get barred in their state individually. So if there's 50 states, each state operates differently. Right now, most of them, a majority of them, if you take the uniform bar exam, you will be barred in their state automatically. But when you have to file one of these, a Pro Hac Vice, some states operate differently. Busbee's from the great state of Texas, right? So when he filed this, he didn't get access to practice in all of the state of New York. He got practice and authorized to practice in some of the state of New York, not the entire state in totality, just a smidge of it, not the whole thing. Not the whole thing. Shout out to Akeem, who became a member. Thank you so much, Akeem. Welcome to our Chatterhood. We have fun over here. We have a good time. You're gonna enjoy it. That being said, guys, let's just jump right on into the receipts and the tea, and let's see what's going on. Starting with the latest news, this was filed. I have two things. One was filed today, and that's this. This is filed against Diddy, right? This is a memo in opposition of the plaintiff's amended motion for admission Pro Hac Vice for Tony Buzbee. Now, this Tony Buzbee thing is a mess. Why is it a mess? In my opinion, a can of worms was opened. And that's when we saw Jay-Z come through and he's like, hey, listen, we have one of these, people that are listed in the lawsuit as Celebrity A and Celebrity B. When the lawsuit was originally filed, the Jane Doe lawsuit, where she couldn't remember going to the VMAs and there were some things that were sketchy. An NBC interview came out. I don't know why Tony Buzbee put his client on NBC. All of that stuff happened. Now, crazy part about all of this is Buzbee and Jane Doe dropped the charges against Jay-Z. This bombshell came out in December of 2024. We're now in February. Those charges against Jay-Z really didn't go beyond 2 months. Now, this original case was filed in October, where he was listed as Celebrity A. Celebrity B is a woman. We don't know who she is at this point in time. Celebrity A filed in October. And they say, hey, Celebrity A, which we've learned is Jay-Z, if you do not settle with us, we're going to reveal your name to the press. And in mid-December, that's exactly what happened. They revealed Jay-Z's name to the press. Interesting, right? Jay-Z went on full defense mode and was just like, you're not going to do this to me. And I'm sorry. The Beehive came through. Like Queen Bee came through. Everybody that supports Beyonce was just like, go ahead. Try to break up this family. Do it. Like, let's see what happens. But I will say that the Roc Nation team fought this tooth and nail to make sure that Jay-Z would not be affiliated, number one, with the Diddy allegations, because that would be a huge hit to the brand. But at the same time, it's not even the brand affiliation. It's also like, did you do this? Like Jay-Z has children now. And these kids have to go to school looking at these news articles and what people are saying about their dad. It got dirty with Buzbee. We learned that another woman sued Buzbee because Buzbee gave her they contracted some type of like disease. I don't know. I talked about that last month. We had that whole thing. That was tea. And then in addition to that part, we also had more allegations of Tony Buzbee just filing these lawsuits to file them. We have a whole Diddy docket. It's not just 22 lawsuits civilly. You've got Diddy fighting everything that's happening on the criminal side, but on the civil side, Buzbee is leading the charge with all these people that are alleging that Diddy did something to them. And let's be real. If you think that these people are lying, I mean, I do think that some of these allegations, if there were 2,000 phone calls made and Buzbee was, the 1-800 lawyer, like, hey, if not Jay-Z, if Diddy harmed you, please call this 1-800 number behind me. He did a press conference. Big red letters, big red numbers. This is the number you call if you've been assaulted. They got 2,000 inquiries, and they boiled it down to like the best 100 cases. Now, if 22 of these cases are compromised because they were filed in the wrong jurisdiction, that's a problem. Why? When you have a plaintiff and a defendant in a civil case and you file a complaint against them, one thing that's really important, I learned this in civil procedure, any attorney can tell you this in law school, civil procedure. It's the first class you take in law school, the first one. It's how to file a lawsuit correctly. That's the first thing you learn in law school. And you need to have 3 things. Subject matter jurisdiction, meaning that it is the right subject matter that the court can weigh in on. I'm not going to go to a criminal courthouse or, a criminal space and talk about defamation there, because a defamation claim is a civil claim. That's not a criminal thing. You can't go to jail or put somebody in jail because they defamed you. That's a civil thing, and you need to prove it in front of a jury. So that falls in a family of injuries to people that we call torts. There are crimes and there are torts. Defamation falls in the torts bucket, right? So subject matter needs to be correct. The next thing that you need to have is personal jurisdiction. That's really where Buzbee has a problem here. Personal jurisdiction means, does the court have authority to pull somebody into court, to haul them into court? Do I have jurisdiction over that person? If this person's from Nebraska and I'm from Massachusetts, what do we have in common? How do I pull somebody that's a citizen of the United States, but also resides in Nebraska? They're also, they've got ties to Nebraska. Can I pull this Nebraskan to Massachusetts if they've never been here? Where did the crime or tort take place? Did it take place in Massachusetts or Nebraska? If it took place in Massachusetts, I can haul your ass over from Nebraska. Maybe. Depending on the circumstances, it depends. But like, if New Mexico just automatically comes into the fold, then we can't necessarily do this. So when it comes to personal jurisdiction, the person has to have contacts, ties, and relations, or the incident must have taken place in that state. So with these 22 lawsuits that we're looking at, these 22 lawsuits probably had something to do with the incident taking place in the state of New York. Now, Pro Hac Vice, we have the personal jurisdiction. We have subject matter jurisdiction, venue. Also makes sense. The venue is the place. It's the courthouse that you pick. Is that courthouse in New York or is it in Nebraska? If it's in New York, you have to have those other two things: subject matter jurisdiction and personal jurisdiction. And then venue is the last step. That's where you file the lawsuit. Now, Buzbee filed 22 of these lawsuits in the Southern District of New York. The state of New York is an entity in itself, but the Southern District of New York is on the federal level. You have the state and federal. Whenever you have parties of a civil case, the other thing, this is where it gets deeper in the legal space, is diversity jurisdiction. So if one person lives in Nebraska and the other lives in Massachusetts, you need to make sure if you have that, a couple things happen. The issue at question costs more than $75,000 and the people are from two different states. That's the problem that we have here. Buzbee is a Texan attorney, but his clients that he solicited with this 1-800 phone number, they all had injuries, alleged injuries suffered to them in the state of New York. Buzbee's not barred in New York, so he has to file Pro Hac Vice. This is what he has existing right now. The Supreme Court of the state of New York, Third Judicial Department, certifies that Anthony Glenn Buzbee is duly licensed and admitted to practice as an attorney and counselor at law in all courts of this state on January 17th. Has duly taken and subscribed the oath of office prescribed by law and has been enrolled in the roll of attorneys and counselors at law on file in this office, is duly registered with the Office of the Court Administration, and according to the records of the court is currently in good standing as an attorney and counselor at law. And it looks like, this is somebody, the clerk registered this and their commission expires on January 29th, which was like about a month ago. Buzbee posted this. What you're not seeing on the other half of the stream or screen is a post from Tony Buzbee. He says, I receive many press inquiries and make no effort to respond to most. I prefer rather to make a one-time general statement and let the various entities use that statement as they see fit. Over the past week, I've gotten multiple inquiries from friends and colleagues expressing concern and asking why I have been barred from practicing in New York State and offering their assistance. I myself have seen several press agencies, some borderline legitimate, reporting that same trash. Let me be clear. I am licensed to practice law in New York. Now, ladies and gentlemen, let's talk about that. Tony Buzbee posted this. And remember, this has been entered into the record as Exhibit A. Why? Why? I am authorized to practice law in New York. That was his sentence. New York's a complicated state. Are you authorized to practice law in all courts in New York? The Supreme Court in New York? The state of New York? What about the federal courts in New York? That's what we're not seeing, Buzbee. That is what we are not seeing. That was filed today. So the defense team put that forth today. Let's keep going with his statement. He says, I myself have seen several press agencies, some borderline legitimate, reporting the same trash. Let me be clear. I'm licensed to practice law in New York. I'm in good standing with the state bar and always been. Though I prefer Texas, I'm proud of the legal work we are doing in New York. Don't believe the clickbait or dramatic headlines. Most of what's reported nowadays is pure bunk by those with an agenda. Okay, Busbee. That's his statement. That was Exhibit A. The defense team goes to the judge and says, listen, don't grant Buzbee this. Don't do it. Don't do it at all. Why would you do it? Diddy's attorneys were strategic with this. Why? They're strategic with this for a reason. Jay-Z went in on Buzbee. I have those docs that we're going to look at too. But he went in on Buzbee in a specific way. Number one, it was discovered that Buzbee wasn't necessary, even though he had this certificate to be able to practice law, Pro Hac Vice in New York. What that means, it's a Latin term. You need to have another New York attorney assisting you to make sure that you're complying with New York laws. Every state operates differently, and the laws can be different. The laws of Massachusetts are going to be different from California. They're going to be different from Georgia. They're going to be different from Texas. Sometimes there's nuances. Some states might look at particular crimes, criminally or civilly, differently, right? But this is a federal case. And so Buzbee needed the assistance of a New York attorney. That was questioned while Jay-Z was trying to get his name off of this lawsuit. It was questioned. He's like, get it off. Why are you coming to me? Get my name off of this lawsuit. I don't want to be involved in this. This woman is not telling the truth. She can go after Diddy, but she's not coming after Hove. That's what happened. So now what happens is, because we all know Diddy might have done some of this stuff. We saw the tape. We saw the Cassie thing. Like, there's no doubt. Like, we've seen the tape. That's hard to refute. Shout out to Akeem. But that really is hard to refute, that he had nothing to do with that when we have you on tape dragging Cassie down a hallway, doing all this stuff. It's very difficult for you to say that you didn't do that, but we saw you doing it. Now, the other things are very procedural, and we could see his legal team trying to bring that in the ways that they're bringing it in. Now, because Jay-Z was successful in getting these charges dropped against him, and let me tell you something, Jigga is not done. H to the OV is not done. He is suing Buzbee in California. There was a hearing yesterday at 9 a.m. And the judge cleared Jay-Z to sue Buzbee on defamation. It's starting to get real. So what does Diddy do? Diddy's like, well, if that got dismissed, can I get these other 22 cases off of me too? I mean, Hove just got him to say he wasn't barred in New York, like fully. In the state of New York, yes, for state law claims. But in the Southern District of New York, which is federal, he's not barred there. So then Tony last week, he files an application to get barred there. He files a federal application because without that, then he doesn't have diversity jurisdiction and he cannot bring the 22 claims. What Diddy's team is saying is y'all allowed him to bring in the 22 claims. These are where we start to talk about legal, loopholes, right? You're going to see more of that. You really are. Okay. So let's see what Diddy's team says. They have a table of authorities, factual background, four things. One, Buzbee brings over 20 cases in this district while he was not admitted to practice law before this court. Next, a opposing counsel brings to light that Buzbee is not admitted. He has a lack of admission. Next, Buzbee is denied admission to the Southern District of New York. Next, Buzbee files the instant motion in response to a court order. So that was that little seal I showed you guys. He filed that to get in here quickly. And honestly, if you filed that in 2019, you should have done it for the entire state. Do it all. Do the state of New York, state-wise and federal. He didn't do the federal side. So you see how there's a problem where Jay-Z opened a can of worms. Where are you guys at on the poll? Did Buzbee's issue with Jay-Z open a legal can of worms? 90% of you say yes, 10% of you say no. Thank you guys for voting in that poll. I'm going to keep it up throughout the entire stream, but I'm just curious to see what you are thinking. So this was filed late last night, right around midnight. I'm not going to go through the legal standard, maybe a bit of it, maybe some of their argument, but I don't like to go through too much of that. Here's their table of authorities. These are all the cases and the rules that they're citing. And what I do want to show you is that there's a New York rule of professional responsibility. What does that mean? They're trying to say that Tony Buzbee was not being ethical. Whenever you see these rules, that means the rules of ethics come into it. Because here's the thing, he showed us that seal. I'm barred in the state of New York. Yeah, you're barred in the state of New York. You know what else applies to you? The rules of professional responsibility. So what I want to see what the defense says here. But it shows rules here. And whenever you see more rules than cases, there's a 1, 2, 3, 4 cases here. But there are more rules listed than cases. So it is likely, before we even read this document, guys, that they're saying that Tony Buzbee broke rules. Shenanigans. Let's keep going. Defendants, and I don't know where the title went here. It's gone. That's already a mistake. Defendants, Diddy, all his businesses submit this memorandum of law in opposition to plaintiff's amended motion for admission to Pro Hac Vice for Tony Buzbee. Prelim statement. In our collective decades of practice, undersigned counsel have never opposed a Pro Hac Vice application. Damn. These lawyers are like, we are experienced, but we've never filed a document like this ever. It's like, oh, we're starting that way. Well then. And let me make myself small so y'all can follow along. But Buzbee's egregious misconduct warrants denial of the privilege of appearing in this district. He has signed multiple filings across 22 cases without permission to practice in this court. He failed in each instance to disclose that he had filed without being admitted. God damn. And he violated the New York rules of professional conduct by, among other things, repeatedly insisting that Diddy is guilty of the criminal charges pending against him in this district, even though Buzbee has no good faith basis to believe the government will call any of his clients as a witness in this case. For these reasons discussed in detail below, this court should deny Buzbee's Pro Hac Vice application. See, this is what happens, and we talked about it a little bit with Relly in the A$AP Rocky case. Sometimes if you have one case end up in a certain result, depending on those results, it can impact your other cases. Shout out to Full Drinking, Half Thinking, right? And we will take a quick, let's do it right now. Shout out to E. Capone, hits me with the $10 super chat, says, AV, long time no see, hits me with the $7 Cash App as well. Thank you so much, E. Capone. No comment, no question, pure love of the game. Then Full Drinking and Half Thinking Trin has stopped by with the $15 super chat as well. Thank you so much, Trin. I hope you're doing well. I believe you're a resident of New York. Says, okay, finally found some time. What's up, mama? Chatterhood, what up? Hope all is well. Have a shot on Full Drinking and Half Thinking. It's Wednesday. Stay the course. That's right. That is right, guys. Like I'm bouncing from meeting to meeting, video to video. We are working hard over here, but I'm just happy that I was able to pop in and go through these documents with y'all. Thank you so much, Full Drinking, Half Thinking. Check out Trend. If any of the mods are hanging around, please drop the link to his channel. Let's go to their facts. And the facts are interesting. Whenever I see an A or a 1 or a 2, that means they're going to have multiple points within their facts. It says Buzbee brings over 20 cases in this district while not admitted to practice before this court. That's a problem. That's coming at somebody's professional ethics, but also now think about if you're Diddy and you have like 60 cases against you. And if you could just trim the fat and count out 22 because this lawyer was not barred in the state correctly. Kind of a problem. Kind of a problem. As plaintiff's lead counsel in this case, Buzbee has for months been signing and upon information and belief, drafting, directing, and advising on pleadings and other filings in this action without obtaining permission to practice in the Southern District of New York and without disclosing that he lacks such permission. God damn, it's over right there. It's over right there. See motion to leave to proceed. Pseudo-anonymously. That's crazy. Buzbee's declaration. Okay, these are all the documents that are there. Buzbee has done the same thing in 21 other cases filed in this district, all brought on behalf of plaintiffs proceeding anonymously. So they knew it was him. It was his legal fingerprint. They were like, Buzbee, you did this. Everybody's a Jane Doe or a John Doe. Oh, I mean, it looks like your handiwork. Everybody. Buzbee, everybody. While filing lawsuit after lawsuit without authorization, he has repeatedly promoted his cases with statements that violate New York rules of professional conduct. In countless social media posts, media appearances, and a press conference, Buzbee has inappropriately commented on pending litigation in a manner that violates his professional and ethical obligations by, among other things, opining on Mr. Combs' guilt on criminal charges that are scheduled to be tried in this district beginning on Cinco de Diddy, May 5th, 2025. That being said, guys, I'm curious now. Now I'm super curious. I want to see the Buzbee press conference one more time. When we watched it originally, dear viewer, you and I were in the middle of the YSL trial. And we played it. But I think in retrospect, it could be very important for us to come here. Here it is. Let's watch it one more time and see where we're coming from.
Hello, everyone. My name is Tony Buzbee. I'm a lawyer here in Houston. I'm licensed in Texas and in New York. and I'll introduce other members of our team as they speak. As many of you know, our law firm has been at the forefront of some of the most important litigation in the United States. We like the tough cases. We thrive in the complicated cases. We've handled over the last 25 years some very big and very important cases. I believe that this one may surpass them all. There are many facets to this. The conduct we will describe today occurred over more than 20 years. There are many people and many entities involved. And we're going to follow this evidence wherever it takes us. We will find the silent accomplices. We will expose the enablers who enabled this conduct behind closed doors. We will pursue this matter no matter who the evidence implicates. These brave victims who have stepped forward deserve nothing less. The biggest secret in the entertainment industry that really wasn't a secret at all has finally been revealed to the world. The wall of silence has now been broken, and victims are coming forward. Our team has had at this point more than 3,285 individuals contact us with people claiming to have been victimized by Sean Combs. After vetting, we now represent 120 individuals who intend to bring civil claims in civil court against Sean Diddy Combs, as well as claims against many other individuals and entities that we will name as defendants as we file these individual cases. And you should know, to the extent the clients feel comfortable, we also intend to make these individuals available to the authorities, specifically to the FBI. And you should also know a few of them have already been spoken to by the FBI. Now, before we discuss the nature of the claims and claimants themselves, let me comment on the large volume of calls we have received since our first announcement. Even before the indictment of Sean Combs, we had received a small volume of calls and had screened a handful of cases. After the indictment of Sean Combs and the announcement that we were pursuing these claims, the floodgates opened. People who wouldn't otherwise, for a variety of reasons, are now stepping forward to make their voices heard and to pursue justice. But no, most of these people are scared. They fear backlash in their communities. They fear backlash in their own families. They are afraid of retaliation from the perpetrators and their associates. They are rightly afraid for their own personal safety. I expect that through this process, many powerful people will be exposed. Many dirty secrets will be revealed. We know what we are potentially up against. And as is always the case in situations like this, when a celebrity is involved, people can be downright mean and nasty. You'll be shocked at the length fans will go, no matter the evidence to the contrary, to defend celebrities they love. I mean, there's a reason for this word fans. They're fanatics. I've personally already been threatened multiple times on social media. And when I agreed to pursue this, I expected as much. This isn't my first rodeo. But victims
we know
to have their voices heard should not be subjected to that kind of conduct. They should not be targeted. I want to say this, and I want to be clear about it. Although we are vetting each call as stringently as we can, I always start with a mindset that I believe victims. I believe victims because I understand the tremendous courage it takes to step forward. So if you're watching this, please hear me. If you're out there and you have been victimized, you are not alone. There is a great strength in numbers. You can seek redress. You can obtain justice. We can help you, and we will help you. That being said, as stated, we are vetting every call that we receive. We have had to turn away some. For each, we ask for corroboration. For each, we ask for the identity of witnesses. We also have collected pictures, videos, texts, we check venues, we check dates.
Do
we
you
want to corroborate that the claims being made?
This is why I like going back to video footage like this. This came out in September, October, where Diddy was arrested. I think it was October. It's not until Jay-Z gets involved that his attorneys question everything. And they were like, hell no. Did your client actually have any interaction with Jay-Z that night? Because we have photographs of him over here. The VMAs didn't even have a Megatron as described. The woman says that her dad drove her 5 hours down to the VMAs, and sorry, someone else drove her, who is dead, by the way. The person that drove her down is dead. We don't even have their testimony anymore. And then the father drove 5 hours down to pick her up from upstate New York. The story didn't add up. And so the Jay-Z legal team just like poked holes at that. But he just said that with the claims that are being made, that they are fact checking everything, that they're reviewing everything, that they're making sure it makes sense. Queen Brielle, he has a backdrop. He has a whole phone number. Let's keep going.
Have legitimacy and merit. We have on staff now a former detective from the Major Offenders Unit of Houston Police Department who is helping us vet each claim. We're using our common sense. We're being stringent because, as I said, these are not easy cases. They're very tough. The process is hard, and in some cases, the process is very lengthy. These cases are hard to prove. Many times it's the victim's word against the alleged perpetrator. Each of these victims will no doubt be publicly attacked by the alleged perpetrators, and in some cases, the general public. The feckless and cowardly keyboard warriors love to attack. We know what we're up against. We did not enter this fray blindly. I wish it was my last such fray. I wish this type of behavior wasn't so pervasive, but it is what it is, so we will press on. As I said, our law firms have been retained by 120 individuals at this point.
You're about to lose 22.
In civil court against Sean Diddy Combs. You should know, in this group, it is evenly divided between males and females. There are 60 males and 60 females who have joined us to pursue these claims as plaintiffs. In this group, 62% identify as African American, 30%
I don't
white,
know what's going on
the
with
remainder
the
Hispanic or Asian.
clip.
The victims are from more than 25 states.
Let's go back.
You should know, in this group, it is evenly divided between males and females.
It's evenly divided between males and females. So he was telling us straight up that they had a population of men and women, and if there's 100 cases, that it's half and half. That's what he told us back in October. Okay, let's listen to the next part.
There are 60 males and 60 females who have joined us to pursue these claims as plaintiffs. In this group, 62% identify as African American, 30% are white,
black,
and the remainder are Hispanic
30%
or
white,
Asian.
and
The
then
victims
Hispanic
are from
or
more
Asian.
than 25 states. The majority are from California, New York, Georgia, and Florida.
So let's think about that. 22 of your cases are in jeopardy in New York. California is one of the largest states. So, of course, we can project that you're going to have some victims in the state of California. New York, Georgia, and Florida. Florida makes sense because Diddy had the Miami property. Let's keep going. But remember, guys, it's so fascinating to watch this back from October and to see where this man is today.
I don't want to focus on of these victims. When we talk about the ages of the victims when the conduct occurred, it's shocking. Our youngest victim at the time of the occurrence was 9 years old. We have an individual who was 14 years old.
I cannot stand the wheel of
We have
death.
one who was 15. 25 of the 120 individuals who are plaintiffs in these cases were minors at the time of the acts complained of. The time frame of the acts complained of is very wide. The conduct at issue spans from the years 1991 all the way till this year, 2024. If you wonder why there are so many alleged victims, that's your answer. We're talking about more than 25 years of this type of conduct. Now, although most of the victims who have stepped forward were victimized after 2015, this has been going on for a very long time. Now, when you think about the fact that some of this conduct occurred 25 years ago, and you wonder why would it take somebody so long to step forward, I want to remind you that many states in the United States have recognized that it's very difficult for a victim to step forward and to make these types of allegations when something very terrible has happened to them. I'll use New York, the state of New York, as an example. The state of New York has specific statutes in place that revive claims that are even claims that would typically be not able to be brought, that it revives such claims and they can be brought even 25 to 30 years later. Because there's a recognition there in New York and California and other states that it's very difficult for a victim to come forward. And I would respectfully suggest the only reason many of these people are coming forward because they see other victims coming forward. And it gives them some comfort that, hey, I won't be the only one. And I expect more victims will come forward. You know, there's an old saying that says, a lie has great speed, but truth has endurance. The acts complained of in these cases that we're going to file occurred primarily in New York, either Manhattan or the Hamptons, or occurred in California, primarily in Los Angeles, or in Florida, primarily in Miami. Most of these events and incidents occurred at parties, typically after parties, or album release parties, New Year's Eve parties, 4th of July parties, something they called a puppy party, all-white party, although several of these events occurred at auditions.
What is a puppy party? Shout out to Florida Sunshine Reports with the $20 super. Thank you so much, sis. It says, hey, AV, Happy Bird here. Finally posted my first video. Thank you for inspiration and advice. Always happy to help. Happy Bird. Y'all go check out Florida Sunshine Reports. New content creators. Check them out.
Many times, especially young people wanting to break into the industry, were coerced into this type of conduct in the promise of being made a star or in the promise of having Sean Combs listen to their tape or even let them read for Sean Combs. You should know that some of this behavior occurred at well-known venues in New York City. Some of this behavior occurred at private residences of people that we all know. Some of this behavior occurred at hotels that we're all familiar with. You should know that more than 55% of the victims filed reported this conduct to either the authorities, that is the police, or to hospitals. We're in the process of collecting with our team assistants, medical records, reports that were made to the authorities. And I've already said that some of the individuals in this group did in fact talk to the FBI. You should know that several of the individuals, and when I say several, I mean many, who did in fact seek medical treatment were drug tested, and drugs were found in their system, weird drugs that you probably never heard of. One in particular that continues to pop up is a drug called xylazine or trank, which based on our research is known as a horse tranquilizer. Now, there's been a lot of reports that we're filing a class action. This is not a class action. Class action is when one or two people file a case on behalf of a group of people. That's not this. These cases will be individual cases. Each case will live and die on its own merit. These cases will be filed individually, one plaintiff against whoever the defendants were involved in the case. Each case may be filed in one venue like California, another case may be filed in New York.
That's where we are going to pick it up. I wanted to come here because as we're looking at today's document where Buzbee said that, and he's not even authorized to practice law in the Southern District of New York, where he filed 22 of these lawsuits, is crazy work. The defense team says worse, he has falsely accused Mr. Combs of abusing dozens of children, and maybe that's where the puppy party comes from, where Diddy has never been charged with such crimes. Since October 14th, and that's the press conference we just watched, y'all, Buzbee has directed the filing of at least 22 actions in the Southern District of New York against Diddy and a slate of entities associated with him. From October 14th to January 29th, Buzbee directed the filing and litigated cases in this district without having applied for regular or Pro Hac Vice admission. From October to January, Buzbee never indicted a single action in this district that he was not admitted here, that he had no application pending here, and he had not sought admission Pro Hac Vice. What does that mean, guys? He never filed this admission to practice law in the Southern District of New York correctly. And so what does that mean for the victims? Let's say they're telling the truth, 22 cases. Somebody is telling the truth. Diddy probably did something to somebody, right? If he did. Imagine being a victim that's trying to get justice for their claim, and you're not even authorized to practice law in the place where we file the case. This is the first class in law school. It's civil procedure. It's the first class. The first class is how to file a lawsuit. Where, when, how. It's instructions. That's what civil procedure is. If I'm a victim and this happened, I would be so pissed. Or since some of these people allegedly were children, imagine how their parents feel. Are you dropping the ball, man? So when we look at Diddy's team filing this after Jay-Z's team found that he was not barred in the Southern District of New York, he fumbled that other lady's case. Buzbee fumbled that one. They had to drop the charges, or at least drop the case, withdraw the case in totality, because it was so much of a dumpster fire. Now, if you have 22 of these cases in jeopardy because you made a mistake, this is actually groundbreaking, y'all. I mean, it is like, attorneys make mistakes like this. The classic one says this is malpractice, in my opinion. And that's what I'm saying. Like, I'm not taking a side. A lot of people tend to think that whenever I make an opinion, I'm taking sides. I should just be a scale on the screen. I should just be a scale, right? But at the same time, if I was practicing as an attorney, I want justice for my client. It doesn't matter what side you're on, whether it is a victim, whether it is Diddy. The fact is that we're all ethically obligated to do the right thing for our clients. And that means if I'm a Texan lawyer, I need to make sure before I file a lawsuit in another state that I have the authority to do that. And you don't half-ass the authority. It's like, okay, I did it for the state of New York, but you need to check the state's requirements. Some states require more. In this instance, New York did. You can practice in the state statewide, but like not on the federal side in New York. That's what he didn't do here. Crazy. Crazy, crazy. Let's continue. It goes on to say, opposing counsel brings to light Buzbee's lack of admission. On December 13th, counsel for Sean Carter, born December 4th, also known as Jay-Z, other celebrity Buzbee sued without a good faith basis, filed a letter and related action before the Honorable Judge Torres, which disclosed that Buzbee had not been admitted to practice in the Southern District of New York. See that? That took place on December 13th. This Diddy legal team has been in the cut watching. They're like, oh yeah. Even though it's like Jay-Z's legal team had to figure that out. But it's also like, oh, you're not authorized to practice here. They've been watching this for weeks and trying to figure out what they want to do. And yes, guys, please get the likes up. The algorithm is like totally screwing with me. Last week we had 4,000 people in chat. I think Monday we had almost 1,000. Today it's like 200. It's just like, all right, you don't want me to talk about Karen Reed? Shit, I won't, algorithm. I don't know what you want me to do. Anyway, thank you so much. Allegedly, maybe. Counsel for Jay-Z, they went in front of Judge Torres, which disclosed that Buzbee had not been admitted to practice in the Southern District of New York, having signed numerous pleadings and other filings in the district. And the subsequent motion for sanctions filed on January 8th, Jay-Z's lawyers noted that Buzbee had still not obtained admission for Pro Hac Vice, and further observed, indeed, although Buzbee advised the court on December 20th that he was admitted to practice in the Eastern District of New York and intended to apply for reciprocal admission to the Southern District, he has not even sought interim admission Pro Hac Vice. That's messed up. So they found out in December you could not practice there. After December, you didn't even make the effort to apply to practice there, even though you have 22 cases. On the Breakfast Club this morning, they had mentioned that Buzbee probably was using a specific tactic for these cases, and that was to get Diddy and any other celebrities involved to strong arm them to the point where they would want to settle. Didn't happen with Jay-Z. He's like, no, we're not doing that. Crazy work. In response, Buzbee attested on January 22nd, this is like a month ago, guys, that his application for admission was forthcoming. This representation was false. He didn't do it. Even so, Buzbee took no action until January 28th. Well, 6 days later, Judge Torres directed Buzbee to file proof of admission on the docket by February 14th. Buzbee finally applied the following day for admission. Even though at the time Buzbee had filed multiple actions in this district, he did not notify any of those courts that he had not been admitted to practice here, nor did he seek admission Pro Hac Vice. Buzbee is denied admission to the Southern District of New York. Ooh, he was denied. I did not know that he was denied. It was still pending. I've been watching a lot of people talk about this these past few days. I did not know that he was denied. On February 13th, Judge Filia, chair of the Committee of Grievances, issued an order denying Buzbee's request for admission. Wow. You have 22 cases. And 2 weeks ago, you were denied admission. You can't even practice. What happens to those clients and their claims? They called this number. You told them to call this number. They called it. You got denied? Oh, wow. This is huge. Buzbee was denied admission because, per the committee's review of the dockets, Buzbee has appeared in cases in this court without seeking admission. That's a problem. That means that he thought he had admission because he had that little stamp. And He was never authorized to practice law in the state. Diddy might have 22 of these cases dropped. Jesus. Because the legal technicalities, guys. Do you see this? I don't want to be one of these 22 people. The final sentence on the order denying admission states, in the event Buzbee moves for Pro Hac Vice a regular admission in this court in the future, he must attach a copy of this order denying admission to his motion or petition. They're like, listen, you're going to come back? Show us that we denied it. So we have a record that it's been denied. This is humiliation in the legal space. Damn. This is bad. Buzbee took no steps to notify this court or any other court in this district where his actions were pending that he had been denied admission to practice here. Instead, in this action and others, Buzbee continued to appear on court filings without disclosing the adverse action to the district's grievance committee had taken against him without seeking admission pro hac vice. This is really fucked up, y'all. I'm not even gonna lie. This is bad. So they denied him on February 14th, and he still kept doing work on cases like everything was fine, signing his name. I wish I could. I wish I could. Next, Buzbee files the instant motion in response to the court order. But you didn't do it up here. Oh, this is funny. There was a date in January, yes, right? It took him like 6 days to respond to something, yes. January 22nd, and he didn't take any action until January 28th, so it took him 6 days for that. But when they denied this man, do you know that he came back the next day and filed an instant application for Pro Hac Vice only after the court required it? Following the receipt of the pre-motion letter response to the Buzbee law firm letterhead, signed only Buzbee, this court issued the following order. The court notes that the plaintiff's letter in opposition to the pre-motion letter filed by Marriott International is signed by Tony Buzbee. The court has been informed that Buzbee is not admitted to practice in the Southern District of New York. He has not filed a motion to appear pro hac vice in this case. As such, Buzbee is in violation of Local Civil Rule 1.3. Accordingly, it is hereby ordered that Buzbee must file a motion to appear pro hac vice no later than February 21st. That was 5 days ago. The court further warned that failure to comply with the court's orders, the federal rules of civil procedure. That's what I mean. Civil procedure is the first class in law school, the first one. The local rules or this court's individual rules of practice may result in sanctions. On the eve of the court's deadline, what did he do? Buzbee filed his first motion to appear pro hac vice in this case. First one in this case. Which was also his first motion to appear pro hac vice in any case in this district since he began filing cases against the defendants on October of 2024. Oh my word. And this is what they were talking about in the Breakfast Club this morning. You wanted settlements. You wanted money. You wanted bread for all these people because what can happen is you can get a piece of those settlements, the 3%. I think that he thought if he littered Diddy with lawsuits that they were just going to fold because of what? Cassie's lawsuit last year. Damn. This is interesting. Taj Juliana, it's good to see you, sis. She says Civ Pro was my first law school exam. Me too. It was my first class. It's 101. So to see this ninja do this is crazy work. Buzbee submitted an affidavit in support of his first motion, to which he was admitted as required by local rules of the Southern and Eastern Districts of New York, that he was recently denied admission to the Southern District of New York. In the affidavit, he stated that he had been denied admission following the filing of a grievance against me by counsel for one of the defendants in the action which I was counsel. Buzbee declared that he was unaware that a grievance had been filed against him at the time he applied for admission in the Southern District, and understands that the filing of a grievance is a disciplinary action under the rules of the Southern District of New York. Buzbee implied that he was denied admission for the Southern District for the same reason the grievance was filed against him, primarily because he electronically signed numerous pleadings alongside his firm's local counsel without being admitted here. Throw the damn case out, all of them. Buzbee averred, to the extent I violated the Southern District's rules, those violations were inadvertent, and I would make certain such never occurs again. You know why I have a problem with this? And I don't want to make it about race, but like if another attorney made a mistake like this, disbarred, get out. Get the F out. I don't care if you made a mistake. Get out. Inadvertent mistakes, they let him stay on. Yak did have court today, said, but Law and Crime wasn't there, so it wasn't nationally televised. I think some local creators covered it. Sylvia might have done something on that. But shenanigans, guys. Shenanigans. Buzbee also submitted a copy of the order denying admission issued by the Committee of Grievances as required by the text of the order. The first motion was supported by a declaration of Ms. Curis, Buzbee's local counsel. In her declaration, which is undated, states that Ms. Curis was advised by Buzbee that he had never been censured, suspended, disbarred, or denied admission or readmission by any court. The court directed plaintiff to refile the first motion for several filing deficiencies. This is bad. This shows you make mistakes in your filings, including because the submission was missing a certificate of good standing from the Supreme Court of Texas, missing a proposed order, and missing a wet signature from Buzbee. Oh, he didn't even file the paperwork right. He didn't file anything from his state. He didn't file anything with a proposed order. He didn't even sign the damn thing. Like why are we here? Plaintiff filed an amended motion for Buzbee to appear pro hac vice on February 24th, 2 days ago, and it is identical in all respects to the first motion, but purports to resolve the deficiencies. So a new lawyer came in to represent Buzbee and fix all the things that he did wrong. Apart from this motion, Buzbee filed in this case for being directed to do so by court. Buzbee has not filed a motion to appear pro hac vice in any other case. Is pending in this. What? Oh my God, y'all. 22 cases and he's only trying to fix one. Diddy might get these dismissed. Shit. Not in a bad way, but it's just like, okay, I really feel bad for the victims. If something did happen, a mistake of your attorney, this one, the mistake of this attorney, fuck your whole case up. You ain't getting no bag. What bag? Whose bag? Oh, this is awful. I'm so sad for these people that actually called that number to file a claim. They talk about the law in the state of New York. This is the legal standard, Local Rule 1.3c, which governs Pro Hac Vice admission, provides that a lawyer duly admitted and in good standing in another state or in any United States district court may be permitted to argue or try cases in whole or in part as counsel or advocate upon motion. So they have to apply to the court. The court has to grant it. That's the rule governing that. Their admission is a privilege, not a right. So you're not automatically given this thing. For granting Pro Hac Vice, courts are required reasonable assurance that such attorney is familiar with the federal rules of civil procedure, the local rules of the Southern District of New York, and the court's individual rights. This is, that's mean. That's saying that as an attorney, when you're applying here, we're going to assume that you've already looked at this, but the federal rules of civil procedure, and Ty Giuliani could tell you that's the first fucking thing you learn in law school. The first thing, how to file a case and where, why, how to do it properly. Tony Buzbee couldn't get that right. This is very bad for his brand and his law firm. I would never want, if I was practicing, I would never want somebody to talk about me like that. In addition to considering whether the attorney seeking Pro Hac Vice demonstrates the requisite familiarity with local practice, the court may consider whether the applicant instills confidence that their representations might be relied upon. Although admissions are routinely granted, the court's decision to not do so is simply a pro forma exercise, and there are occasions where such an application have been denied. All right, this is their argument. Buzbee's motion for admission should be denied because he has repeatedly shown that he is unwilling or unable to follow local rules, and because his application is deficient. That means the guy didn't even fill out the fucking form right, like at all. Like, he just didn't fill it out right. Sorry for those who don't like when I swear. For nearly 5 months, Buzbee has filed case after case in this district against defendants in the name of anonymous plaintiffs without seeking admission of any kind and without disclosing his lack of admission until raised by a court or adversary, the other side, the other attorneys. He did not apply for admission to practice in this district until January 29 of 2025. More than 6 weeks after his failure to do so was publicized in a letter filed by its opposing counsel. 5 weeks after he represented to another judge in this district that he intended to apply for admission, and he never did. And 2 weeks after he represented to another judge, 2 judges in this district at this point, that his application was forthcoming. He never did it. When it comes to these ambulance chasers, what people say are ambulance chasers in civil claims, this is when you're not paying the lawyer. It's very different from criminal law. When you're paying an attorney on the criminal side, like you're like, listen, I want the best I want Taco Pina representation. I want Brian Steele representation. I'm paying you. It costs money, thousands of dollars per hour, hundreds of dollars per hour. But with ambulance chasers, so to speak, what happens is you're not paying them. You're paying them on contingency. You're paying them with 3% of whatever you're awarded at the end of your civil claim or your settlement. It's 3% of that, a third. No, not a third, but there is typically a percentage that attorney gets from your final award. And when you get big money like that, you don't give a shit. You're just like, yeah, whatever. But because you see that this payment process is different, when you're paying somebody on the go, it's earned. When you're paying somebody on the go, it's different. When you're paying somebody with the result of it could work out or it couldn't work out, you get half-ass results. Not always, because I do think generally attorneys want to do their jobs. But this is a good analyzation exercise for everybody because you're looking at this. I know I said 33% and a third. I'm sorry, Elijah. I'm sorry, other people. Elijah. I mean, I make mistakes from time to time. But let's just call it a percentage. I'm not going to give you the exact. But at the end of the day, something is earned versus not earned. You could see the difference in representation. And something like this, 2,000 phone calls. You did research for the 100 best cases. Did you? They're all, and he said it to us. He just said it in this press conference here. He just said it here. They come from New York, California, Florida, 4 or 5 states. Hold on. Hold on. Hold on. No sound, no sound, no sound, no sound. No sound, no sound, no sound. Hold on. Hold on, y'all. I had to refresh. That does happen if you switch between using StreamYard. If you switch between windows often. I do that a lot. So we've learned that. It happens. I'm going to bring it back up. We were somewhere around here.
Defendants were involved in the case. Each case may be filed in one venue like California. Another case may be filed in New York. One case may sue just Sean Combs, but multiple other people. One case may sue a range of people. I would expect most, though, to be filed, as I said, in New York and Los Angeles. Now, I know this. Many of you came here thinking or hoping or perhaps believing that I may start naming names. Well, that day will come, but it won't be today. The day will come when we will name names other than Sean Combs, and there's a lot of names. It's a long list already. And of course, I already know who some of these individuals are, but because of the nature of this case, we're going to make damn sure that we're right before we do that. But the names that we're going to name, assuming that our investigators confirm and corroborate what we've been told, are names that will shock you. These are individual cases.
Jay-Z.
There are indeed other perpetrators involved. They will be revealed when that particular individual case is ready to be filed. They already know who they are. And I'm talking here about not just the cowardly, but complicit bystanders. That is, those people that we know watched this behavior occur and did nothing. And I'm talking about the people that participated, encouraged it, egged it on. They know who they are.
Did you say Jay-Z?
I call them the facilitators of foul play, willing participants in vile conduct. As we identify them, each will be part of this case as defendants. These defendants will not only include individuals, but would also include corporate entities who ultimately profited off of this culture and behavior. I'm looking at banks, pharmaceutical companies, hotels. We know that many of these individuals were paid cash. We know that many of these individuals involved, whether they were the ones being assaulted and abused, or they're witnessing other people being assaulted and abused and then paid and threatened and told to leave. Typically paid 10 grand in cash and told to leave. And then threatened as they were leaving. So in addition to Sean Combs, you should know the defendants in these cases we're going to file will include anyone, of course, who engaged in the assault or exploitation, anyone who participated in such in any way, anyone who encouraged or facilitated this conduct, anyone who was in the room and watched it happen but made no effort to stop it, any venue or venue owner who was aware of what was going on but failed to stop it, Any individual or entity who knew about the conduct and benefited from it, but did nothing to report it or stop it. And any individual or entity who covered it up or helped cover it up. These people who know who they are should just come forward now. I would imagine,
come settle.
as we speak here, there are a myriad of people.
Come give me your money.
Nervous. You can't hide skeletons in the closet forever. I would expect there are many people out there right now who are desperately searching their memories as they delete their texts and data. Now, although these are, in fact, individual cases, there is a common theme, an MO, if you will. Typically, the victim is lured into a situation where he or she is given a drink. Typically, that drink, reported by these victims, apparently laced with something. Once that drink takes effect, the perpetrators perform all kinds of sexual acts on the victims, many times passing him or her around as other people watch and enjoy the show, and then leave the victim ashamed, confused, injured, and wondering what happened. When the victim reaches out, he or she is told not to say anything. Sometimes there are threats of physical violence or financial repercussions or bodily harm. The claims we intend to bring will include the following: violent sexual assault or rape, sexual abuse, facilitated sex with a controlled substance, false imprisonment, compelling prostitution, sexual misconduct, dissemination of video recordings, false imprisonment, sexual abuse of minors. Given the large volume of cases, and given our other docket obligations, and given the fact that we want to be sure when we file these cases they are fully vetted, I expect we'll start filing these cases against Sean Combs and other perpetrators within the next 30 days.
And they did not. They did not file them all within the next 30 days. It's just, I mean, like, this is just hard because if you really are a victim, if you get the wrong lawyer and they fumble the ball like this, how do you get justice for what happened to you? Because, like, let's be real, guys. If 2,000 phone calls, not all those phone calls are real. 100 cases. Somebody in that group of 100 actually had some Diddy shenanigans happen. Like, let's just keep it 100. I mean, I think some of them are factual, but when you have somebody fumble the ball like this, it's just so absurd. Even after Buzbee was expressly put on notice by the Committee of Grievances that making repeated submissions to this court in a district where he was not authorized to practice violates the local rules, a concept so fundamental to the practice of law requires no forewarning. They're calling him dumb here. Buzbee took no corrective action. Instead, he continued making filings in this district without noting his lack of admission until this court required him to seek Pro Hac Vice admission. If this court had not noticed that Buzbee was practicing without being admitted, there is every reason then 20 other cases pending in this court. Sorry, I skipped the line. There is every reason to believe he would have continued to do so because it is precisely what Buzbee is doing in more than 20 other cases in this court. So he was just going to continue to practice without authorization. That's like me doing that. It is frowned upon. If you are not barred or licensed to practice, it's not okay. That's why we have the model rules of professional conduct in every state in addition to federal. You can't just be a lawyer out here saying you're a lawyer, but you're not really a lawyer and you're not barred to practice in that state. You can't do that. It's wrong. That's why we have these rules to protect us and to protect clients from, shenanigans like this. Even after declaring in a February 20th, 2025 affidavit submitted to this court, his errors were inadvertent. He admitted, oh yeah, I'm not barred, but I didn't mean it. Just have me no harm, no foul, no problem. I didn't mean it. We can't do that when we go to jail for crimes. Oh, judge, I didn't mean it. What is this guy talking about? I'm really disappointed here. His errors were inadvertent. He will make certain such conduct never occurs again. He has failed to seek admission pro hac vice in any of the other cases. At best, Buzbee's repeated violations of the local rules, as he puts it, inadvertent, meaning he didn't mean it, and demonstrate his unfamiliarity with the practice in this district of New York. At worst, the serial violations demonstrate that the court cannot rely on Buzbee to make reliable representations and conduct himself professionally and ethically. Whichever explanation this court credits, Buzbee's conduct warrants denying him the privilege of appearing pro hac vice before this court. Courts in this district have used their discretion to deny even unopposed motions for pro hac vice admissions when plaintiff's counsel repeatedly fails to comply with the local rules, casting doubt on the counsel's competence to practice here. That's the case that they cite here. It's another case. There's a few cases that they cite. I'm gonna skip through that. This court cannot reasonably be assured that Buzbee understands or will follow the local rules and customs because he has shown time and time again that he cannot. After being directed by the court to file a motion of admission, he has not done so. He should have done it when the first case was filed months before. Buzbee, his motion was deficient. He failed to provide a certificate of good standing from Texas in violation of Rule 1.3K. He failed to provide a proposed order to the court to grant and include a wet signature. I know that sounds funny. A wet signature means we're going to sign it. Wet from a pen. Not, a computerized signature. Wet from a pen. You sign. He also failed to provide a proposed order to the court to grant and include a wet signature as the attorney seeking pro hac vice status in a filing made from another lawyer's Pacer account. What? In a filing made from another lawyer's Pacer account. I don't even have time to go in on that. Additionally, Buzbee's conduct on this case, unrelated to this pro hac vice application, demonstrates his lack of understanding to the local rules and local practice. In the early days of this case, he violated Rule 10A of the Federal Rules of Civil Procedure and 614 of New York electronic case filing. He doesn't know what he's doing. Under a pseudonym without first seeking a leave of court. Ordering a plaintiff to file in her own name and noting counsel's failure to seek leave to file anonymously for doing so. Diddy might get these 22 cases dismissed. Even crediting Buzbee's claim that his repeated violations of the rules governing practice in his district were inadvertent. He didn't mean it. The court can and should use its discretion to deny the motion for pro hac vice because Buzbee's apparent lack of familiarity with local practice and his failure, even after to do so, to take corrective action in his other cases pending this district. Moreover, his application is deficient. They talk about what the rule is. He doesn't file it correctly. I think it's just more and more of Buzbee not doing this right. Buzbee has also repeatedly violated New York rules of professional conduct. For example, their rules prohibit attorneys who are participating in a civil matter from making extrajudicial statements. Don't talk about it on the news. That the lawyer knows or reasonably should know materially prejudicing the adjudicated proceeding in the matter. A statement is likely to prejudice if that's the rule. What did he say? Tell me what he said. The lawyer may only state the following with elaboration. So this is what you can do in the state of New York as an attorney. You could talk about the claim, the offense or defense, and except when prohibited by law, the identity of the people involved. You could talk about information on public record. You could talk about an investigation as a matter as it's in progress. You could talk about the scheduling. You can request assistance or evidence or help, tips, a warning of danger so you can inform the public. But in New York, that's all you can do. It says here, oh, they got him again. Buzbee's frequent press appearances clearly violate this rule. For example, in a press conference Buzbee held on October 4th, that's the one I just showed y'all, to advise the launch of his campaign against the defendants and promote a 1-800 number to viewers to call to make claims against Diddy. Buzbee described in great detail the expected testimony of several of the supposed 120 individuals on whose behalf he claimed he would be filing lawsuits. That's right, we watched it. Describing his clients, Buzbee said, "It's shocking to hear the youngest victim at the time of the occurrence, was 9 years old, and claimed to represent 25 minors." I just showed y'all that. He did say 25 minors. Implicitly accusing Diddy of grave criminal misconduct, which he has never been charged. Buzbee went on to describe in detail his client's expected testimony, where they would say the alleged assaults occurred and circumstances in which they would claim the assaults took place, the nature of the relationships his clients would claim they had with Diddy prior to the assaults. His clients would allege Diddy used to effectuate the assaults, assaultive conduct, blah, blah, blah. They go in here for the kill. Buzbee did not just preview his client's testimony on general terms. He relayed anticipated accounts of the as of then unfiled allegations from the unnamed clients. He did. We can go back, y'all. He did. He said, this is what you can expect to see. We're going to go after the people that were complicit, the people who didn't say anything, the people that participated. Jay-Z's name wasn't revealed until December, but this press conference took place in October. In describing his client's expected narratives, he claimed that he corroborated, vetted, and collected evidence for each of the accounts, vouching for the truthfulness of his clients and allegations and implicity of Diddy's guilt. After the press conference, Buzbee went on to participate in a media blitz. I just lost my place. Campaign to promote his lawsuits. In doing so, he routinely implied that Diddy has a predilection of predatory assaults, commenting on and degenerating his character. There can be no serious dispute, and those statements materially prejudicing this and other adjudicative proceedings. Okay, blah, blah, blah. As a result, Buzbee's knowing failure to seek admission while continuing to practice in this district, his violation of local rules. Buzbee does not merit the privilege of appearing pro hac vice because the court cannot be confident in his representations to the court that can be relied upon. And they have more case law here. See how they ended. When the question of Buzbee was permitted to practice in this court came up in other matters, he expressly represented that he was in the process of getting admitted, but his implied and express representations were not true, and he knew they were not true when he made them. Buzbee did not apply for admission to any court in this district and in any capacity until Judge Torres gave him a 2-week deadline to do so and to show that he had proof that he actually did it. Even after Buzbee's failure to obtain permission to practice was brought to attention by his adversaries and other judges, Buzbee still failed to take action steps to correct his mistake. Moreover, his public statements reflect that he does not appreciate the gravity of his violations. Indeed, rather than acknowledge the limitations of his practice, his practice authority in the face of public inquiries. Buzbee instead chose to make a public statement that deflected, claiming reports of him being barred from practicing in the state of New York were trash and pure bunk, and boasting, although I prefer Texas, I'm proud of the legal work we're doing here in New York. That's Exhibit A that I showed y'all. Anyway, the defendants respectfully request that the court deny his application to practice Pro Hac Vice.
Now, it's rare, sexual abuse, sexual exploitation, this type of activity is pervasive in our society, and it's rare we get a chance where we can really focus on this as a country and really focus on this about how pervasive this is and what we as collectively can do about it. So I thought I'd take this opportunity before I go into some of the individual cases and talk about some of the individual claims being made and so you'll get a sense of what this 120 people group looks like individually. I want to bring forward Carrie Paul. She's a national victim advocate who helps victims who have been victimized by this type of conduct. And she has some important words, and I hope you'll pay close attention. I think it's important that you hear from her.
Hello, I'm Carrie Paul with the National Victim Advocate. It's not easy for any survivor to come forward. Our culture doesn't believe survivors. It blames and questions them.
So this is hard to hear, but shout out to Pam Salters, who gifted 20 memberships. If you got a membership from Pam, please say thank you. We posted something else earlier. She's like, I want to give membership. So I was like, Pam, thank you. Eddie got a membership. Gray got a membership. Lulu got one. Count Cracula got one. Proud Marine Mom got one. Nene got one. Another mom. Andrew, Donna, R. Hutt, Scales, Monica, Cheney, Nikki, Rob the Trader, Good Girl, Gabby, Tread, Destin. I think that's most of them. Got a membership from Pam. Please say thank you to her. Out of respect for this young lady, I am going to see if I can skip her part and just go to other members of Buzbee's team, or rather when he comes back. But thank you so much, Pam. Interesting stuff there. Disclosing
the victim's name. You probably know that depending on the age of the victim, you can file these individual cases under Jane Doe or John Doe. Each state is different in that respect. Typically, there is a balancing test, like the public's right to know the name of the victim and plaintiff versus the confidentiality and the safety of the plaintiff. So we'll have to struggle with that with each one of these cases. Our intention, of course, is to, like we always do, file these cases under a pseudonym until the court tells us otherwise. But let me share with you a few, just kind of give you a sense of the kind of cases and the kind of instances that people are calling and reporting that we are trying to corroborate, vet, and these are the ones that we've already corroborated, vetted, and collected evidence on. One individual who was 22 years at the time she was assaulted said that the typical MO at one of these parties that have been widely discussed in the press was that when you were handed a drink, and now we know that the drink is laced with something, if you refused to drink it, you were kicked out of the party. Now let that sink in for a minute. I mean, the admission to this party was that you had to drink the chosen drink that was handed to you. And now we know that in most cases, I would say 90% of the cases, these individuals were drugged with some sort of drug. That was kind of the MO. Another instance, this individual who was 9 years old at the time was taken to a audition in New York City with Bad Boy Records. Other boys were there to audition as well. All of them were trying to land a record deal. All of them were minors. This individual was sexually abused, allegedly by Sean Combs and several other people at the studio in the promise to both his parents and to him himself of getting a record deal. Another instance, another minor
9.
told allegedly by Sean Combs that he would make him a star, but he needed to visit with him in private about it, away from his parents. Once they were in a private area, allegedly Mr. Combs made the victim perform oral sex upon him. Another incident, an individual 15 years old at the time, flown to New York City to attend a party, was drugged, and then taken into a private room, allegedly in the presence of Mr. Combs, where this female individual, minor, was raped, and then other individuals took turns raping her. Another individual, 26 at the time of the occurrence, was picked up allegedly by Mr. Combs and several other people in a black SUV from the airport.
That's. Did y'all hear what he just said? Allegedly was picked up. Tony, you're supposed to know this. Tony, these are your clients. You're not supposed to use the words allegedly. At this point, you and your team should have thoroughly walked through this, thoroughly collected what you needed for the investigation, thoroughly did what you needed to do for your clients. These are sad allegations. These are sad stories, if true. Notice that I'm using words like if true and allegedly because I'm not there. I'm not their lawyer. I haven't performed an investigation. I haven't talked to law enforcement. But the fact that this man right here said allegedly is crazy work.
Was given one drink in the SUV and then literally woke up the next day not knowing what had happened, but with pain and damage to both her vagina and her anus, where she then went to the hospital. She was missing her underwear and her shoes. Another instance, an individual, this time not a minor, attended a group dinner, allegedly with Sean Combs in Miami. She wasn't drinking because she was pregnant, but whatever she drank at the table, apparently, at least according to her, was laced with something. She blacked out and she woke up in the same bed, again, allegedly with Mr. Combs in his mansion in Miami. Her vagina and her anus were torn and sore. And I could go on. I mean, literally, you're sensing a theme here. It's the same theme, and it all involves.
He said a pregnant woman. I can't.
Some sort of drug. One instance, an individual who was 20 years old at the time was asked to attend, just saw her on the street, asked to attend a party in a hotel. She was flattered, went to the party, was given one drink and doesn't remember anything else. Ultimately, was so messed up, went to the hospital where they found cocaine and this horse tranquilizer in her blood system. I want to give you a quote from a very young man who told us over the phone about his experience and all the things that happened to him. He says allegedly at the hands of Sean Diddy Combs and his friends in the effort to try to sign a record deal. This was kind of what he was told he would have to do. His quote is, "Had he not been in power, I feel like I could have been something great. I quit the industry because of what Sean Combs did to me." And that's really what it comes down to. We are pursuing this, asking you to support this effort, to encourage witnesses and victims to come forward and bring your evidence so we can continue to break down this wall of silence and we can continue to have these stories heard. This is the beginning of what I hope to be a national dialogue. This type of sexual assault sexual abuse and sexual exploitation should never happen in the United States or anywhere else. This should have never been allowed to go on for so long. This conduct has created a mass of individuals who are injured, scared, and scarred. If you are one of those individuals, we ask you to reach out. If not to us, to someone you trust. If you are someone who witnessed any of these events, we ask you to reach out. Your name can remain confidential. With that, I'll take a few questions, not many, maybe two, but if you have a question, I'll be pleased to try to answer it. Perfect.
How many minors are making accusations in total, and are the feds aware of the allegations of minors in the case?
I don't know what the feds are aware of, okay, but I do know it's 25 out of this 120. But I will say this to that point. We welcome the FBI or any authority who wants to come to us, and we're going to make that available to these victims because I think that's important. My suspicion is, based on talking with these folks, is that the FBI is just not aware of these people. The FBI has talked to some of these folks, and I'm going to try to encourage the victims to, in fact, talk to the FBI because I think they have some very important things to say.
Yes. Were all of the children auditioning because they were musicians, or were any of them kids of employees or anything like that?
All seeking either TV or some sort of music career with promises of, we're going to make you a star. Instead, basically did things to them such that they don't want to have anything to do with the entertainment industry.
Well, that's Tony Buzbee's, in retrospect, that was his press conference. Now, Tony Buzbee still has to deal with Jay-Z's defamation countersuit. There was a hearing yesterday, you guys. After Tony Buzbee withdrew the assault lawsuit against Jay-Z 2 weeks ago, the fog around Jay-Z's name began to clear up. Can't say the same for Buzbee, though. Accusing famous and wealthy people isn't without consequence. Not only did it cost him being able to practice in the Southern District of New York, Jay-Z countersued Buzbee, accusing him of defamation and extortion. While Buzbee is still in hot water, a judge recently decided to turn the temperature down a little. Law 360 has coverage. They say a California state judge said Tuesday that he's inclined to toss Jay-Z's extortion claims against personal injury lawyer Tony Buzbee and some, but not all, of the rapper's defamation allegations stemming from a new abandoned lawsuit. The judge's tentative ruling would strike the extortion claim under California's anti-SLAPP statute, which blocks frivolous lawsuits that seek to limit free speech. The judge said Buzbee's demand letter is clearly protected litigation activity. Selling silence for money in the civil context is not extortion, the ruling said. It's a settlement with a non-disclosure element. The protected status of some of the claims is still up for grabs. For example, Jay-Z could still sue Buzbee for defamation, but it would be difficult to prove that Buzbee knew that what he was saying was untruthful. Given Buzbee's team ran a background check on and did several interviews with the anonymous woman who eventually dropped the suit against Jay-Z and Diddy, it does look like they did do their due diligence of asking questions and sussing out the strength of the case before making the allegations public. Either way, it's looking to be a hard knock of life for Buzbee, legally speaking, in the months to come. And that brings us here. The last thing, I'm not going to go too far into it. What a lot of people don't know, and there was a hearing on this yesterday. Sean Carter, born December 4th, is suing the Buzbee law firm and Tony Buzbee directly. A lot of people don't know about this lawsuit. It's flying under the radar. I pulled this yesterday, and I just wanted to see what was going on. This is a document from the Buzbee team saying that, Jay-Z is publicly threatening us with criminal prosecution. Actually, wait, sorry. I think this is filed by Jay-Z's team. Let's go to the back. Yes, attorneys for plaintiff Sean Carter. This was actually 2 weeks ago. We were busy with ASAP Rocky, so we didn't see it. But let's go here. It says plaintiff Sean Carter has filed a well-pleaded claims against Tony Buzbee and the Buzbee law firm for civil extortion, defamation, and intentional infliction of emotional distress. So keep this in mind. The charges from Jane Doe and Buzbee have been dropped against Jay-Z. But Jay-Z is just like, even with that, I'm still suing you, ninja, for all these things that you said to me. But what they would have to prove is that Buzbee intentionally knew that these things were fake. The amended complaint alleges, and there's no dispute, that right after Sean Combs was charged with drugging and assaulting men, women, and children who attended his parties, Buzbee launched a nationwide publicity campaign to attract Diddy victims as his clients. Buzbee claimed that other high-profile entertainers have participated in Diddy's criminal acts and threatened to expose and pursue criminal proceedings against them. That's right. We just watched. This is why I wanted to bring that press conference to you guys. We just watched it. We did hear him say that. To that end, Buzbee sent demand letters to Jay-Z on behalf of two individuals who claimed that Jay-Z had participated in Diddy's criminal enterprise. Oh. So there's another one. It's not just Jane Doe. There's another one. Thank you so much again to Pam for gifting those memberships. Buzbee threatened to publicly pursue Jay-Z if he did not agree to provide something of substance to compensate his clients. Look at the quotes. Something of substance. Give me money. Otherwise, we're going to expose your name. It's not just one client. We always thought it was just one. Buzbee had two of them that were saying that Jay-Z did something. The key issue raised by Buzbee's motion is whether he can wrap himself in California's litigation privilege by claiming that his public and private threats to Mr. Carter were lawful acts in aid of potential litigation. He cannot. Where Buzbee crossed the line, and what sets this case apart from most pre-litigation threats, is that he not only threatened civil litigation against Jay-Z if he did not pay his clients, but criminal proceedings and a public spectacle as well. Ooh, we didn't know that. That renders his conduct extortion as a matter of law and bars him from invoking the anti-SLAPP statute. Buzbee's defense is that he threatened criminal proceedings only in his public statements and did not repeat them in his demand letters to Mr. Carter. I didn't know this. I'm reading this raw dog with you guys. Buzbee threatened to get Jay-Z involved with the police if he didn't pay the settlement for his clients. This is a dirty game. But the law draws no such distinction. Buzbee's statements must be taken in their entirety, and his demand letters to Jay-Z must be read in context. And that's the other thing. If it's a demand letter, we have proof that you wrote it, bro. Like, we just proof that you wrote it. There's proof that you wrote it. To hold otherwise would reward clever extortionists. As to Mr. Carter's defamation claim, it admittedly concerns the matters of First Amendment protected speech. But Mr. Carter presents evidence here sufficient to meet his prima facie burden on the elements of that claim, including constitutional malice. That is likewise the case in his claim for intentional infliction of emotional distress. Buzbee's assertion that there is nothing extreme and outrageous about his false public claims that Jay-Z is a serial child rapist is erroneous and appalling. This court should deny the motion. I'll be honest, y'all. Jay-Z's pissed. Pissed. Like, you can read it. He's pissed. And this took place like weeks ago. Nobody really paid attention to this. I found it as I was doing research today. But I wanted to see, like, okay, the charges were dropped against you, Jay-Z. How are you feeling? And he's just like, nope. You wanted to drag me, I'm dragging you. Wild. After Diddy's indictment in 2024 in September, Buzbee made a public solicitation to represent anyone who claimed to be a victim of Diddy. As a part of that campaign, Buzbee publicly and threatened criminal referrals against anyone involved. I just showed y'all that. Then, in the midst of this campaign, Buzbee sent private demand letters to Jay-Z on behalf of 2 clients, threatening to create a public spectacle unless Jay-Z paid them something of substance. In the context of Buzbee's public statements, these demands were extortionate. Well, put one in the chat if you think these were extortionist type of claims that Buzbee was sending to Jay-Z. Be honest. What do you think? Put a 1 in the chat if you're like, no. He was like, give me the money or you're going to jail. Or 2, if you're like, nope, he was representing his victims. No judgment, chat. No judgment at all. Let us know what you think. It's interesting. Defendants publicly threatened criminal prosecutions. Throughout September and October, Buzbee laid the groundwork for the extortion demands. He boasted on Instagram that his law firm represented over 120 people who had been abused by Diddy and his cohorts, stating that many individuals will be implicated. 2 days later, Buzbee announced a press conference related other perpetrators of crimes. At the end of the October 1st press conference, Buzbee escalated his threats of criminal prosecution, vowing to find the silent accomplices and expose the enablers. He stated that he intends to make his clients available to the authorities, specifically to the FBI. Ooh. You guys are like, ones. Yes, 101. Trizzy says uno. Is he Teresa? He's representing Jake. Girl. Let's go back. In October, Buzbee began to represent Jane Doe. We know all about Jane Doe. On October 2nd, on a podcast, Buzbee pledged to ferret out all people who were involved and facilitated Diddy's conduct and to hold them accountable in civil and criminal cases. The next day, in a broadcast interview, Buzbee restated, I expect the indictment and charges in the indictment will grow. I expect other people will be implicated. So this is threatening to other people that he's pressuring to settle. He warned that those close to Diddy should be prosecuted and put underneath the jail, and that they could be criminally charged or even civilly sued. People should know. On another podcast, this ninja was going and doing podcasts. Buzbee reiterated that his threat of criminal prosecution. He foreshadowed that there were going to be some people named in these cases that are going to raise some eyebrows. Buzbee filed a New York action on October 20th. Buzbee accused Diddy and Celebrity A of getting at Jane Doe at a party when she was 13. He did not disclose the person's name. Defendants privately threatened to expose Jay-Z. On November 5th, defendants privately sent extortion demands to Jay-Z on behalf of the two clients, Jane Doe and John. Oh, the other person's a John Doe. Oh. Jane Doe, that case is dropped. Now I understand why Jay-Z is fighting this. The other person is a John Doe. It's a man! Oh my gosh! I didn't know that. Whew. The letters accused him of harming both individuals when they were minors. The Jane Doe extortion demand made clear that Jay-Z supposedly was the not identified celebrity A in the New York lawsuit. Buzbee warned that the only way to avoid the public spectacle was for Jay-Z to provide his clients of something of substance in the settlement. Buzbee also threatened to pursue Mr. Carter for supposed crimes that Buzbee had not even identified on behalf of persons he did not represent. Here's a quote. It has been my experience that when someone does this to a victim once, the likelihood that they have done it the same or similar things to others. I mean, I would be bad too. To say that Jay-Z did this to a man? What? Buzbee's accusations are categorically false. Declaration of Sean Carter, but the extortion demands combined with Buzbee's prior public threats sent a clear message to Jay-Z: pay up or face criminal charges and public condemnation. The extortion demands came with a 2-week deadline, warning that if Jay-Z failed to comply, the defendants would take a different course. Mr. Carter understood from Buzbee's campaign of public threats combined with private demands for money that Buzbee would create a public spectacle, including a criminal referral, if Jay-Z did not buy his silence. After sending these letters to Jay-Z privately, Buzbee intensified this media campaign with more threats of criminal prosecution. Around November 14th, a film produced by TMZ, Buzbee threatened those who attended Diddy parties, calling them just as guilty. Buzbee said that some alleged victims of Diddy had already spoken to authorities and that he was encouraging all of them to do so. When Jay-Z refuses to be extorted, defendants defame him. Instead of caving to the extortion, Jay-Z filed this lawsuit anonymously on November 18th. Okay. All right, Jigga. Buzbee responded by publicly tying his prior media statements to Mr. Carter. In a flurry of social media posts, Buzbee branded Jay-Z as a rapist. On November 18th, Buzbee posted on Twitter that Jane Doe was a survivor. The next day, Buzbee liked a Twitter post suggesting that Jay-Z was celebrity A. In response to Jay-Z's refusal to bend to extortion, because he was like, Jay-Z, bend the knee, bend it, bend the knee. And Jay-Z said no. Buzbee threatened on social media to publish the extortion demands. Since our professional efforts of resolution obviously have failed, we will instead disclose the demand letters. On December 8th, Buzbee amended the complaint in New York to explicitly name Sean Carter, Jay-Z as Celebrity A, who supposedly harmed Jane Doe at a party in New York City in 2000. 2 days later, Buzbee even went further in a statement to TMZ, where he said he's not ruling out filing rape charges against Jay-Z with New York authorities. Buzbee also said that Jay-Z's accuser might take the music mogul's advice and file a criminal complaint against him after slapping him with a civil lawsuit. 5 days later, that's the NBC interview. They discredited Jane Doe's story and revealed that Buzbee had not investigated her claims. Chief among the deficiency that NBC revealed, contrary to her allegations, her father had no memory of making the 10-hour round trip from Rochester to Manhattan to pick up his teenage daughter from this party. Defendants never spoke to him to corroborate her allegations, nor did they seek to confirm that Benji Madden, whom Jane Doe claims was there at the night of the incident, was in attendance. Madden could not have been because he was performing in the Midwest that night. Instead of owning his failure to vet Jane Doe's claims, Buzbee pinned it on another law firm and suggested that his client take a polygraph test, which she did not do. Oh, man. I'm not going to go through the legal standard. Their argument will read the headings. Step 1, Buzbee's extortionate conduct is unprotected. Defendant's conduct is extortion as a matter of law. Next. Defendants failed to show that John Doe demand is privilege. I want to read this because I don't know much about the John Doe thing. I didn't even know there was a second lawsuit. Defendants argue that Jay-Z's extortion and intentional infliction claims are barred by litigation privilege. The argument fails. Courts determine whether a pre-litigation letter is protected under anti-SLAPP law by assessing whether it was made in good faith contemplation or of imminent litigation. As to the John Doe extortion demands, defendants cannot meet their burden. First, defendants fail to show that they intended in good faith to pursue litigation. Their only evidence is Buzbee's self-serving declaration. My firm and 2 of our clients were prepared to assert civil claims against Jay-Z. The letters were sent in good faith. They were serious anticipation of litigation. Buzbee's recitation of the good faith standard is not enough when the attorney relies solely on his self-serving declaration that in his own mind at the time that he submitted the claims, his mindset was that litigation would be necessary. Skipping. Defendants failed to show that they contemplated intimate access to the courts to resolve John Doe's accusations. Defendants sent the John Doe extortion demand 3 months ago, but they never sued on his behalf. Oof. Their inaction exposes that letter for what it is, a hollow threat of litigation. Finally, the defendants failed to show that they sent the John Doe extortion demand to achieve objects of litigation. Instead, defendants resort to, whatever this word is. They claim to have sent the demands in anticipation. All right. So with John Doe, you have Jane Doe, you have John Doe saying that Diddy and Jay-Z did something to this young man. They never filed a goddamn lawsuit. It was an extortion letter. Pay or we're going to tell. This is crazy. Next, step 2, Mr. Carter will prevail on the merits. Not going through that. Next, he's met each of the elements of his defamation claim. Defendant's statements are false assertions of fact, not opinion. Oh, there's things about pedos in here. I'm gonna link this in the description box. This is giving me a headache, y'all. I just I can't believe that there's a John Doe in here, a young man. Anyway, we have been on for about 2 hours. I really want to thank you guys for stopping through, participating in the live stream today. We have a very, very big announcement on Friday. I will be doing an interview on my YouTube mentors channel, Daryl Eves. He has about 600,000 subscribers. Coach to Mr. Beast, coach to so many creators, including myself. Daryl's a great, solid guy. Producer, I believe, director of the show Chosen on streaming services. So we're really excited to be able to collaborate on this. I'm just really happy that he had faith in me and what I'm supposed to do on this platform. Has been a great mentor over these past few months to stick with this work and to continue to do this legal work and to show you guys like what happens in the legal system every day. I didn't know about John Doe. But these are the things when you have a guy that knows this stuff and talks to you about it, it just becomes really easy. But I'm pumped to be able to talk to him this Friday. I'm going to put it on my community tab at 2 p.m. Eastern Standard Time. Check it out. It's it's a little bit of a vulnerable moment for me because last year was a really tough year. And I needed to find guidance in other places, and I found it in that community and in that group. So I was really excited about this and having an opportunity to do an interview like this. I think it's huge. So I'm excited. I hope you guys tune in. I want to give a huge shout out to the people that have contributed to today's stream. Akeem, welcome. E. Capone, thank you for the Cash App and the Super Chat. Full drinking and half thinking, stop through. Drew Beats popped in. Full drinking, half thinking again. Florida Sunshine reports. Deonra, Miss Pam Salters, and she also contributed to other pieces that we put out today. So thank you guys. Stay safe out there. We will be back. Things are heating up. We've got a lot of stuff to catch up on, but we'll see you in the next one. Bye.